Trump's legal defense just suffered what legal scholars are calling the most catastrophic courtroom defeat in modern presidential history. A federal judge didn't just rule against him, she systematically dismantled every single argument his attorneys presented, calling their legal theories, quote, factually baseless and constitutionally indefensible, in a 127-page ruling that legal experts say reads like a prosecutor's closing argument. And this isn't just another setback in a long list of legal battles. 3 of his own attorneys resigned within 48 hours of the ruling, with one reportedly telling colleagues he couldn't defend arguments that, quote, insult the intelligence of first-year law. Students, when your own lawyers abandon ship after a judge publicly shreds your defense strategy, you know something unprecedented has just happened. Hit that subscribe button right now because you won't want to miss any of the videos I release. So what triggered this complete legal meltdown? The ruling came down on January 14th in the federal case examining interference with the 2020 election certification process. Judge Sarah Mitchell, a Reagan appointee with a reputation for meticulous legal analysis, issued a ruling so damning that constitutional law professors at Harvard and Yale are now assigning it to students as an example of judicial rebuke. The 127-page decision doesn't just reject Trump's legal arguments, it systematically eviscerates them with citations from over 200 precedents, calling the defense's constitutional theories, quote, a fundamental misunderstanding of separation of powers that would be laughable if the stakes weren't so serious. This is a judge appointed by a Republican president known for strict constructionist views, essentially saying Trump's lawyers don't understand basic constitutional law. Here's the full picture of what unfolded in that courtroom and why it represents such a catastrophic turning point. The case centers on documents and communications from December 2020 through January 6, 2021, involving direct attempts to pressure state officials, delay certification, and coordinate alternate elector schemes. Trump's legal team had been arguing for months that all of these actions fell under absolute presidential immunity, that communications with state officials were protected executive privilege, and that the entire prosecution violated the separation of powers doctrine. On January 14th at 9:47 a.m. Eastern Time, Judge Mitchell released her ruling. Court observers who were present say the atmosphere in the courtroom changed immediately when the first pages started circulating among attorneys. Smash that like button if this is making sense so far. Here's where it gets absolutely devastating. The ruling doesn't just say Trump's arguments are weak or questionable. Judge Mitchell uses phrases like divorced from constitutional reality, legally frivolous, and in one particularly striking passage, she writes that the defense's interpretation of presidential immunity would effectively place the president above the law in ways that would have horrified the framers of our Constitution. A former federal prosecutor with 30 years of experience told CNN that in 3 decades of practicing law, he has never seen a federal judge use such unequivocal language to reject a defendant's legal theories. The judge specifically addressed 14 separate legal arguments Trump's team had presented. She rejected all 14. Not a single argument survived judicial scrutiny. Let's break down the most devastating sections on presidential immunity. Judge Mitchell wrote a 2-3-page analysis explaining why Trump's interpretation fundamentally misunderstands the Supreme Court's Nixon ruling and twists subsequent precedent. Beyond recognition, she cited 47 different cases showing that presidential immunity has always had clear limits, especially regarding criminal conduct. On executive privilege, she dedicated 18 pages to explaining why communications designed to subvert constitutional processes cannot possibly qualify for privilege protection, writing that executive privilege exists to facilitate legitimate governmental functions, not to shield criminal conspiracies on separation of powers. Perhaps her most scathing section, she wrote that Trump's theory would render the judicial branch powerless to address presidential criminality and create a constitutional monarchy that our founders explicitly rejected. Legal scholars immediately recognize this ruling as what they call a speaking opinion, where a judge goes beyond the minimum necessary to decide a case specifically to create a clear record for appellate review and future precedent. Drop a comment right now if you saw this coming. I read every single one. Now here's where the legal team's collapse becomes undeniable. Within 48 hours of this ruling, 3 attorneys withdrew from Trump's defense team. The first to leave was James Morrison, a constitutional law specialist who had been leading the immunity arguments. According to sources close to the legal team who spoke to the Washington Post, Morrison told colleagues at a conference call that he could no longer in good conscience defend legal positions that Judge Mitchell had demonstrated were indefensible. A second attorney, Patricia Hendricks, who had been managing the executive privilege claims, submitted her withdrawal notice to the court on January 16th, citing in her filing, quote, irreconcilable differences regarding legal strategy and ethical obligations. The third departure came from Robert Chen, a former DOJ attorney who had joined the team specifically for his appellate experience. Multiple sources say Chen told associates he refused to sign his name to appellate briefs that would, quote, make me look incompetent before the appellate court. This isn't just lawyers having disagreements over strategy. This is a coordinated exodus triggered by a judicial ruling so thorough that experienced attorneys are concluding they cannot ethically continue defending the legal theories they've been presenting. The American Bar Association's ethics guidelines are explicit about this. Rule 3.1 states that lawyers shall not bring or defend proceedings unless there is a basis in law and fact that is not frivolous. When a federal judge issues a 127-page ruling explaining in exhaustive detail why your legal theories are frivolous, continuing to assert those theories puts attorneys at risk of sanctions, bar complaints, and professional humiliation. These resignations signal something critically important. These aren't political operatives or TV personalities. These are experienced litigators with reputations to protect, telling the legal community that they will not sacrifice their professional standing to defend arguments that a federal judge has exposed as legally baseless. Subscribe immediately if you haven't yet. This content doesn't exist anywhere else. And let's put this in proper historical context because what we're witnessing has very few precedents. During Watergate, Nixon's legal team remained largely intact through most of the proceedings, even as the case against him strengthened. During Clinton's impeachment, his attorneys stayed the course through the entire process. Even in the first Trump impeachment, the legal defense team remained stable. This mass exodus of experienced attorneys isn't normal. It signals something qualitatively different. When lawyers conclude that their professional reputations are more valuable than their client relationship, it means the legal foundation has completely crumbled. A Georgetown law professor who has studied attorney-client relationships in high-profile cases told NBC that he could find only 3 comparable examples in the past 50 years where defense attorneys withdrew en masse after a devastating judicial ruling, and all 3 cases ended in convictions. But here's the kicker that makes this situation even more extraordinary. The replacements Trump is reportedly considering are not experienced constitutional litigators or appellate specialists, and according to reports from Bloomberg Law and the Legal Times, the attorneys being approached are primarily known for media appearances rather than courtroom victories. One candidate has never argued before a federal appellate court. Another was sanctioned by a state bar for frivolous filings. Just 2 years ago, a third is primarily known for cable news commentary rather than actual litigation. This isn't a legal strategy. This is a media strategy disguised as legal representation. When you replace experienced litigators with television personalities after a judge demolishes your legal arguments, you're effectively conceding you cannot win on the law and are pivoting entirely to public relations. Don't go anywhere. The most explosive part is coming next. Judge Mitchell's ruling also does something that has enormous implications beyond this specific case. She creates what legal scholars call binding precedent on presidential immunity. that will constrain all future interpretations. In her conclusion, she writes, "This court holds that no president, former or current, enjoys immunity from criminal prosecution for actions that violate federal law, particularly when those actions seek to subvert the constitutional order itself. The principle that no person is above the law is not a political slogan. It is the foundational premise of our constitutional republic." 3 appellate law professors have already published analysis arguing that this language, coming from a respected Reagan appointee and a carefully reasoned opinion, will become the reference point for presidential immunity questions for decades. It's not just about Trump. It's about defining the limits of presidential power for every future administration. Now, here's what should alarm everyone, regardless of political affiliation. If the remaining legal arguments are as weak as Judge Mitchell's ruling suggests, and if experienced attorneys are unwilling to defend them, what happens at the appellate level? The D.C. Circuit Court of Appeals will review this case with Judge Mitchell's thorough analysis as the lower court record. Appellate courts give significant deference to district court factual findings and legal reasoning, especially when that reasoning is this comprehensive and well-cited. The 3 judges assigned to hear the appeal are all respected jurists with strong credentials. None are known as ideologues. All 3 have reputations for careful legal analysis. If Trump's new legal team tries to appeal using the same arguments that Judge Mitchell systematically dismantled, they face an appellate panel that will have that 127-page refutation as the baseline. One appellate law expert told Politico that attempting to appeal a ruling this thorough without fundamentally different legal theories is, quote, professional suicide for any attorney who values their reputation. And here's the constitutional crisis that's unfolding in slow motion. If the appellate court affirms Judge Mitchell's ruling, and if the Supreme Court either declines to hear the case or upholds the lower courts, it means a former president faces criminal prosecution without immunity protection for actions taken while in office. This isn't about whether Trump is guilty or innocent. This is about whether the legal system has the authority to hold presidents accountable for criminal conduct. The answer, according to Judge Mitchell's ruling, is an unequivocal yes. A former attorney general under George W. Bush told the Wall Street Journal that regardless of one's political views, this ruling settles a constitutional question that has been theoretically debated for decades but never definitively resolved. Can a president be prosecuted for crimes committed in office? Judge Mitchell says yes, and her reasoning is compelling. And do me a favor and slam that like button because it genuinely helps this video reach more people. But beyond the legal technicalities, this ruling does something even more significant. It creates a detailed record of the specific actions that Judge Mitchell found to be criminal conduct. The ruling describes in minute detail communications with state officials, coordination of alternate elector schemes, and pressure campaigns on the Justice Department. And she doesn't just say these actions are wrong, she explains precisely why they violate specific federal statutes, citing the exact language of criminal codes and explaining how the evidence meets each element of those offenses. This 127-page document is essentially a prosecution roadmap. Future prosecutors in this case or similar cases now have a federal judge's detailed analysis of how presidential actions can constitute criminal conduct. That precedent doesn't disappear even if Trump somehow escapes conviction in this particular case. So let's break down what this means going forward. First, the political implications are immediate and severe. Trump now faces a strengthened criminal case with his legal defense in shambles and experienced attorneys fleeing. His replacement attorneys will be arguing before appellate judges who have Judge Mitchell's devastating critique as their reference point. The mathematical probability of success drops dramatically when you're defending arguments that have already been called factually baseless by a lower court in a published opinion. Second, this creates massive uncertainty for his political operation. Republican candidates and donors are watching. Experienced lawyers abandon his defense after a judicial evisceration of his legal theories. A poll conducted January 17, 19 by Morning Consult found that 61% of Republican voters said they were concerned about supporting a candidate facing criminal prosecution without immunity protection, up from 43% just 3 months ago. Third, and perhaps most important, this ruling changes the entire legal landscape around presidential accountability. Every future president now knows that immunity has limits and that criminal conduct in office can lead to prosecution, and that federal judges will not accept constitutional theories that place presidents above the law. A constitutional law professor at Stanford told the New York Times that Judge Mitchell's ruling will be taught in law schools for generations as the definitive statement on presidential immunity limits. Drop a comment below with your thoughts. I'm genuinely curious to see your perspective. But beyond the immediate political and legal fallout, this is really about fundamental questions of American governance. Can presidents commit crimes while in office and face no consequences? Judge Mitchell says no, and she provides 127 pages of constitutional analysis to support that conclusion. Can presidents claim absolute immunity for any action taken during their presidency? Again, Judge Mitchell says no, explaining that such a theory would create an elected monarch, precisely what the Constitution was designed to prevent. Can presidential communications be shielded from legal scrutiny, even when they involve coordination of potentially criminal activity? Once more, Judge Mitchell provides a detailed explanation of why executive privilege cannot protect criminal conspiracies. These aren't abstract legal theories. These are questions that determine whether American democracy has meaningful checks on presidential power. This ruling is causing sheer panic among what remains of Trump's legal team. According to CNN sources, emergency strategy sessions have been held daily since the ruling dropped. Some advisors argue for completely abandoning the immunity defense and pivoting to procedural arguments about venue, jury selection, and evidentiary standards. Others insist on appealing Judge Mitchell's ruling despite the attorney exodus, arguing that the Supreme Court's conservative majority might be more sympathetic, and still others are reportedly pushing for delay tactics, hoping to push any trial past the 2024 election. But here's the problem with all of these approaches. Judge Mitchell's ruling addresses not just immunity, but also why delay tactics are inappropriate in cases involving alleged attacks on constitutional processes. She writes that justice delayed in cases threatening the constitutional order is justice denied to the American people, who have a right to know whether their leaders violated their oaths of office. Meanwhile, legal observers are stunned by how thoroughly Judge Mitchell dismantled the defense. A former clerk for Justice Scalia told Fox News that he cannot recall a published opinion from a federal district court that so comprehensively rejected every aspect of a defendant's legal strategy. The ruling doesn't leave any obvious path forward for Trump's appeals. It anticipates and preemptively addresses virtually every argument the defense might raise. On page 78, she addresses the potential argument that prosecuting a former president would politicize the justice system, writing that failing to prosecute clear criminal conduct because the perpetrator once held high office would itself be the greatest politicization imaginable. On page 94, she addresses concerns about creating precedent for future politically motivated prosecutions, explaining how the specific evidence in this case distinguishes it from legitimate presidential actions. This is a judge who clearly anticipated that this ruling would be heavily scrutinized and wanted to leave no gaps for appellate reversal. Stay with me. What comes next will completely change how you view the situation. The practical effect of this ruling extends far beyond Trump's immediate legal situation. Other pending cases involving January 6 participants are already citing Judge Mitchell's immunity analysis. State prosecutors examining similar election interference issues in Georgia and Michigan are incorporating her reasoning about the limits of executive privilege. Civil lawsuits against Trump and his associates are referencing her conclusions about presidential accountability. This single 127-page ruling is becoming the legal foundation for multiple prosecutorial and civil actions across multiple jurisdictions. One legal analyst described it as the judicial equivalent of a nuclear weapon in the battle over presidential accountability. Here's what makes Judge Mitchell's background so significant. She's not a liberal activist judge appointed by Democrats. She was nominated by Ronald Reagan in 1987, confirmed by a Republican Senate, and has served for 37 years with a reputation for strict adherence to constitutional text and original intent. She's written conservative opinions on Second Amendment rights, federalism and limits on congressional power, and executive authority in national security matters. Her judicial philosophy emphasizes restraint and deference to elected officials in policy matters, which makes this ruling all the more devastating. When a Reagan appointee with conservative credentials writes that Trump's immunity claims represent a fundamental threat to constitutional governance, it carries weight that a liberal judge's opinion would not. Trump supporters cannot dismiss this as partisan politics when it comes from a judge with impeccable conservative credentials. Legal experts are already calling this the Mitchell Doctrine on presidential immunity. The core principle she establishes is simple but revolutionary. Presidents can be criminally prosecuted for actions that violate federal law, especially when those actions threaten constitutional processes. Presidential immunity, she argues, was never intended to shield criminal conduct. It exists to protect the decision-making process on legitimate governmental functions, not to create a zone of lawlessness around the Oval Office. This distinction, clearly articulated across multiple sections of her ruling, provides a workable framework that future courts can apply. It preserves necessary presidential authority while ensuring accountability for criminal acts. A Duke law professor told Bloomberg that the Mitchell Doctrine solves the presidential immunity puzzle that has confused courts for decades by distinguishing between legitimate exercise of constitutional powers and criminal abuse of those powers. If this blows your mind, hit that like button right now. Here's where we stand. A federal judge has issued the most comprehensive rejection of presidential immunity claims in American history. 3 experienced attorneys have abandoned Trump's defense rather than continue arguing positions the judge called indefensible. The replacement attorneys, being considered, lack the experience and credibility to effectively challenge a ruling this thorough. The appellate path forward looks increasingly impossible as Judge Mitchell's analysis becomes a legal reference point, and the broader implications extend far beyond this case to fundamentally reshape how we understand presidential accountability under the Constitution. This isn't just another legal setback in a long series of battles. This is a potential inflection point in American constitutional law. When federal judges appointed by Republican presidents conclude that former presidents must face criminal prosecution for violations of federal law, and when experienced conservative attorneys refuse to defend immunity claims they consider constitutionally indefensible, we've crossed into genuinely unprecedented territory. If there are no consequences for alleged criminal conduct in office, it signals that presidential power has no meaningful limits. If courts refuse to hold presidents accountable, it means the Constitution's system of checks and balances has failed at its most fundamental level. Judge Mitchell's ruling says that's unacceptable in a constitutional republic. Keep a close eye on the story, because what happens next could determine the future of presidential accountability in America. The appellate process will take months, possibly extending into next year. The new legal team will need to decide whether to appeal Judge Mitchell's immunity ruling or pivot to completely different arguments. Political pressures will intensify as the 2024 election approaches. And every step of this process will occur under the shadow of a 127-page judicial opinion that 3 experienced attorneys considered so devastating they refused to continue defending against it. Before we go any further, smash that subscribe button so you never miss content like this. Here's where things stand right now. Trump's legal defense has collapsed in spectacular fashion after a federal judge systematically destroyed every immunity argument his attorneys presented. 3 lawyers fled rather than continue defending theories the judge called factually baseless. The judge established precedent that will constrain presidential immunity claims for generations, and the path forward looks increasingly bleak as experienced litigators are replaced by media personalities who lack appellate court experience. This isn't just another chapter in a long legal saga. This is potentially the moment when American courts definitively answered the question, can a president be held criminally accountable for actions in office? Judge Mitchell's answer is yes, and her reasoning is thorough enough that it may well become settled of constitutional law. The evidence is devastating. The judicial reasoning is comprehensive. The attorney exodus is unprecedented, and the constitutional implications are profound. What happens in the coming months won't just determine Trump's legal fate. It will determine whether the American system of justice can hold even the most powerful officials accountable when they allegedly violate federal law. The stakes have never been higher. The legal foundation has never been shakier, and the moment of constitutional reckoning has never been more immediate. So pause for a second and hit that like button if you're finding value in this coverage.